India, you have the floor.
India has the honor to address the 6th Committee on the work of the International Law Commission on the Cluster 2 topics. My delegation would like to make brief remarks on the following topics: immunity of state officials from foreign criminal jurisdiction, subsidiary means for the determination of rules of international law, settlement of disputes to which international organizations are parties, non-legally binding international agreements, prevention and repression of piracy and armed robbery at sea, and succession of states in respect of state responsibility. In the topic immunity of state officials from foreign criminal jurisdiction, we commend the work of the Commission and express our appreciation to the Special Rapporteur, Mr. Claudio Grossman-Guilloff, for his second report examining draft Article 7 to 18 as adopted on first reading. We encourage the Commission to continue its efforts with the objective of promoting trust, mutual understanding, and cooperation based on good faith between the fourth state and the state of the official, while ensuring safeguards against possible abuses and politicization in the exercise of criminal jurisdiction over an official of another state. We acknowledge the need to guarantee respect for the principle of the sovereign equality of states, which forms the foundation of the immunity of state officials from foreign criminal jurisdiction. Immunity belongs to the state and applies to official acts performed in the exercise of state authority. This topic is of great significance as it directly relates to the performance abroad of officials of a state. Its consideration requires a balanced approach taking into account existing laws and practices on related issues. On draft Article 7, we believe that the crimes listed must be supported by sufficient state practice and opinio juris. It is important to note that several states are not parties to the treaties where such crimes are defined and contained in the list of the draft article. We affirm our earlier views regarding the Commission's approach to reconciling divergent views of its members and other stakeholders during the next reading of this topic. We welcome the restructuring of draft Article 8 into 2 paragraphs and the addition in draft Article 9 for the sake of clarity. We recognize that draft Article 10 concerning the obligation to notify the state of the official provides an important procedural safeguard. However, the timing and content of such notification, particularly with regard to ongoing investigations and confidentiality, require further consideration. On draft Article 12, we support the requirement of an express waiver which reflects existing general international law and ensures legal certainty and respect for diplomatic relations as recommended by the Special Rapporteur. And in the topic subsidiary means for the determination of rules of international law, we express our appreciation to the Special Rapporteur, Mr. Charles Chenno Jallo, for his third report, which analyzed teachings and other subsidiary means for determining rules of international law, with particular focus on the work of public and private expert bodies and the resolutions or decisions of certain international organizations. We note that the function of subsidiary means is to assist in the determination of rules of international law. On draft conclusion 3, we believe it provides useful criteria for assessing the weight of subsidiary means. The authority of teachings was not necessarily accepted from the outset, but often emerged through a process of scrutiny and contestation. Regarding draft conclusion 4, the current formulation which states that judicial decisions and teachings are subsidiary means may require conceptual clarity. Clarification is also needed as to whether the scope of decisions of courts and tribunals includes the decisions of quasi-judicial entities such as human rights treaty bodies. And in the topic settlement of disputes to which international organizations are parties, we appreciate the efforts of the Special Rapporteur, Mr. August H., in compiling his third report focusing on disputes between international organizations and private parties. India has consistently advocated for the peaceful resolution of disputes through dialogue and mutual consultation. As a founding member of the United Nations, India firmly adheres to the purposes and principles of the UN Charter, including the Pacific settlement of disputes. This commitment is evident in India's approach to disputes in the trade and investment regimes, where we prioritize arbitration and other alternative dispute resolution mechanisms. We believe that extrapolating this concept to international organizations would contribute to the peaceful resolution of disputes between international organizations and between such organizations and states. We take note of the Special Rapporteur's 5 draft guidelines on this topic, which maintain a balance between individual human rights, access to justice, and the need for the independent functioning of international organizations. It would be useful to expand these guidelines to include consideration of diplomatic protection in disputes involving international organizations, differentiation between arbitration based on mutual consent and unilateral arbitration, affirmation of the right to an effective remedy, and a deeper examination of compensation aspects. And in the topic non-legally binding international agreements, we welcome the work of Special Rapporteur Mr. Matthew Foru for his second report, which focuses on the general elements of the topic, including its purpose, terminology, scope, form of outcome, and issues to be addressed to a without prejudice clause. We have taken note of the Special Rapporteur's analysis distinguishing treaties from non-legally binding international agreements based on jurisprudence, practice, and doctrine, and of the next steps to be addressed in future work. One of the questions raised in the report relates to the use of terminology, particularly the preference for the term agreement. The designation of this term requires further discussion in light of its consistency with the Vienna Convention on the Law of Treaties and its Travos preparatories. It should not create confusion or difficulty for domestic legal systems, and there should remain openness to alternative formulations as may be agreed upon by member states. Regarding the draft conclusion 6, the text does not adequately address situations where no explicit provision is made, and it may therefore be useful to elaborate further in the commentary. In the topic prevention and repression of piracy and armed robbery at sea, we appreciate the efforts of the Special Rapporteur, Mr. Luis Savadogo, in identifying key points of law that could serve as major themes for the Commission's work on this topic. We take note that the Commission has provisionally adopted 7 draft articles which broadly reflect the need for a comprehensive legal framework integrating treaty law, customary international law, and evolving state practice. However, the extent of obligations to prevent and repress piracy and armed robbery, as well as the scope of humanitarian duties, warrants further discussion. Emerging issues such as the use of new technologies and the role of private armed security deserve special attention by the Commission. We believe that the Commission's approach seeks to develop and complement existing norms found in UNCLOS, thereby adding clarity and facilitating their implementation. While this work is useful, it should not undermine the existing legal framework governing the law of the sea. With respect to maritime armed robbery, it is essential to address this issue by examining relevant international laws, regional strategies, national practices, and domestic legislative and judicial frameworks. And in the topic succession of states in respect of state responsibility, India attaches great importance to this topic. We welcome the Commission's decision to establish a working group chaired by Mr. Bimal N. Patel to consider the draft report on this subject. We take note of the Chair's expectation, and the revised draft report will enable the working group to proceed efficiently and conclude its work during the Commission's 77th session. Given the complex nature of this topic, it is essential to establish clear and fair rules governing the consequences of state succession, including those relating to state responsibility. I thank you, Madam Chair, for this opportunity.